Yes.
Thank you. My lords, my lady, before the lunch adjournment, I was dealing with the combined grounds of appeal in respect of the pleaded issues and the evidence that Mr. Coventry gave. Before completely departing that, there are two references from the judge's amplified reasons that I just wish to highlight to the court. So it's back to the core bundle, if we may, at page 91. At paragraph 15, I draw the court's attention to the final line of that paragraph, where the learned judge accepted and noted in his amplified reasons that by comparing wands to a curb alternative, Mr. Coventry was considering a situation where wands were installed on the level of the tarmac, not on the level of a raised curb. So the judge even appears to acknowledge that Mr. Coventry's evidence was not in the context of the design failure that essentially he found. And he was talking about wands generally. The second and final reference on this point that I take the court to is overleaf at page 92, paragraph 20. The judge refers back to his conclusion at paragraph 147 of his judgment, which is the key paragraph where the judge essentially finds the defendant in breach of duty for not having installed the barrier of wands. And he repeats that he was satisfied that there was no good reason why that could not have been done. And at the end of that paragraph, he says, I do not recall being referred to any evidence that wands posed a risk of harm to cyclists or other road users, let alone one that outweighed their benefits. I go to those points because in my submission, they really highlight the prejudice here in the finding of breach that the learned judge made. And I repeat my submissions that they were not canvassed on the pleadings, this issue wasn't canvassed on the pleadings, or even the evidence that the learned judge heard. And that, in my submission, speaks to the difficulty, given that this was the issue on which the defendant lost the case, that those are the problems with the judge's approach in my submission. I'm going to move on to the judge's approach to the breach of duty issue, and essentially the failures that I say the failures of reasoning and approach, the matters he didn't take into account but should have done, which culminated in the judge making that finding at paragraph 147. Before I do that, I was going to take the court to Tomlinson and Congleton, but I'm mindful of the time.
Does it really help?
I don't think it does, my
lord. You do know about it.
Yes. I'm not going to take up the time. I don't think it's controversial. The factors that a court must take into account in assessing whether there's been a breach of duty, and that it is not necessarily the case that a danger must be eliminated or warned against. So where does that take us? Well, I've set out in my skeleton in grounds 4 to 6 the matters that the learned judge failed to take into account. I'll begin with one that I've foreshadowed earlier, which is the failure to take into account the low accident rate. And this morning, my Lord Justice Stuart-Smith asked me to remind the court of where the evidence was about the usage of this facility and the evidence of accidents. There are 2 or 3 strands to the evidence. The first is the WSP report that the defendant commissioned. The most useful part of this evidence is the raw data that WSP collected when they did a survey of people using the Farringdon Road cycle facility. That, if I could start with volume 1 of the supplementary bundle at page 272. Your Lordships, your Ladyship should see a table at page 272. and I go here because this is the most useful evidence. It's not the summaries and conclusions which the court can draw and either agree with WSP or disagree with them, but it's the raw data that's the most useful part of the evidence. And what we see here is that WSP did a survey of 7 different step cycle tracks, the top one of which was at Farringdon Road. I don't believe it's exactly this part of the step cycle track, but nonetheless...
It's just south of Clerkenwell Road, isn't it?
Yes, my lord. It's just south of Clerkenwell Road, so it's a little further down south. But what the court will see is that in that section, in the space of 6 hours on a weekday, 2,226 cyclists used it. And on a weekend, where one, of course, would expect cycle numbers to be fewer, 285 used it in that space of 6 hours. So on the space of 6 hours, you have, on a weekday, thousands, measured in the thousands, cyclists using this facility. The WSP report also looked at where cyclists would move. And at a few pages on, at page 276, we have a breakdown of what's been referred to as zone movement for the cycle traffic. And again, at that table at the top, the Farringdon Road site that was surveyed, we've got those figures again for the total number of cycle traffic. And then we can see that 92% on a weekday and 96% at a weekend of those entered at the start of the step cycle track. And then a few entered the step cycle track other than at its start. And the court will see 3% on a weekday and 1% on a weekend. And there is reference to, in this report, to cyclists bumping up onto it. And that's at page 278. I think my Lady Justice Yip mentioned this point this morning, but it's at page 278 in section 4.2.1. A handful of cyclists were seen to bump up onto the curb where there was a height difference. Of course, I should say that not all of that 3% that's moving onto the step cycle track would have been doing it where there was a step. Because as we saw earlier, there were areas further down where there was a depression.
The handful of cyclists to which they refer isn't the same as the 3%, is it?
No.
It's a subset.
It can't. It's a subset, yes, my lord. And that's why I make the point. I don't want it to be said that my submission is that that 3% were all bumping up onto the cycle track. It would have been a handful. But what, of course, the court can take from this is that the step cycle track facility is well used. The vast majority of cyclists use it, and they use it without incident. When the WSP company did their survey, they didn't identify any of those thousands having a problem using it. There was one site on Union Street elsewhere which had a different step cycle track design. Rather than the step cycle track being an incline, that site involved a step cycle track that was formed where the carriageway fell away from the step cycle track. So it was level and then fell away. So that was a peculiar and unique design feature in that location, but no problems anywhere else, and indeed at the Farringdon Road site that was surveyed. So that's the WSP evidence. There was also evidence from Mr. Artis, and this is at page 329. Well, in fact, I won't take the court to the exhibits because they're Excel tables, which perhaps not useful. But Mr. Artis's witness statement summarises it, and that's at page It is page 329, paragraph number 7. Again, this is not the exact site. Mr. Artis isn't referring to a daily counter-cyclist taken at the exact site. It is, again, south of Clerkenwell Road. But it gives an impression in an area not very far away as to the number of cyclists using these facilities. And what we can see is that prior to the step cycle track being constructed, there were, on this daily count, in May 2018, 902 cyclists using the road. In April 2019, which was of course about a year after the construction, the number of cyclists using the road had increased to 2006. And June 2023, over 3,500. And this is where I get the submission that I made to the judge at trial, that there is a real increase, about 300%, of cyclists using the road southbound at Farringdon. As against that, the incident rate of cyclists having collisions with other vehicles and so on has been very low. This is referred to, there are significant, well, lengthy tables referring to this, but and they are at the very end of volume 1, but I can give them to the court. 2015 to 2017, there were 8 incidents.
Hold on. Can we have the reference?
Sorry, my lord. It's page 313 of Supplementary Bundle Volume 1 is the summary of incidents from 2015 to 2017. And the court will find a very long table. And at the end of the table, at page 313, the court will see pedal cycle 8.
Sorry, this is the table of what?
This, my lord, is a table of cyclists that have had incidents on Farringdon Road. Not, I should say, to be absolutely clear, not incidents involving the step cycle track. This is to give an impression of the number of incidents that were occurring with other vehicles and so on, between cyclists and other vehicles.
Between where and where? Does it include the STC?
No, my lord, I don't believe it does. This is incidents involving vehicles. We do get a description of some of them.
I'm sorry, where is it?
Where is what, sorry, my lord?
Well, I don't understand what way to draw from this. You've given us the number of, or you've given us evidence about the number of cycle track journeys, which
yes,
is a large number. And then you're saying an incident rate of cyclists having collisions with other vehicles is very low, and you've taken us to 313, and there's lots of references to Farringdon Road. Also some Farringdon, Slight, so on and so forth.
yes.
But what's the relevance to us? If it's to have any relevance to us, we need to be able to have some understanding of how these rates of collisions relate to the numbers of people
Yes,
using the STC.
I see my lord's point.
Or at least the Superhighway.
I can see it's a different point. That it's a point about the number of cyclists that the step cycle track facility is protecting from motorists. So perhaps I'll come back to that.
Yeah.
In terms of incidents involving the step cycle track, what we have, of course, is the Claimants 2 incidents. There was Mr. Hotop, but as we discussed earlier, his incident was when there was a previous iteration of this facility. All that we have otherwise are some incidents that have been recorded, and these are at the very end of the bundle, bundle 2, page 630 to 633.
So before these accidents, we've got Mr. Hotop's incident,
Yes.
accident which was reported. We've got an email about Kennington Park from Mr. Monk,
Yes. Well, that's a different.
obviously different area. And then the next thing we have is Mr. Murphy's accident in August 2019.
Yes.
No evidence that it was reported at the time.
No.
That's before Mr. Young's accident. Mr. Kay's accident further south
Yes.
is in October 2019, so after Young, but before Upitis.
Yes.
And then on the 21st of January 2020, a week after Mr. Upitis' accident, Mr. Hotop forwards his emails to Transport for London.
Yes.
Is that right?
Correct.
Have I missed anybody out?
No, I don't believe you have, my lord. I can double check, but I don't believe you have. We're looking at a handful. The other evidence that was before the court is that at page 630 to 633. That the part of the difficulty is in it's not clear whether some of these recorded incidents are those to which my lord has just referred, or whether they're different ones. But in any event, there are only a handful. Most of them are in other locations. And for example, at page 632, there's a suggestion that, for example, one cyclist was negotiating a parked lorry and passing back in after a parked lorry when their accident happened. So it is difficult to extract from these reports in those pages exactly which ones involved the Farringdon Road step cycle track and involved confusion between the curb and what was perceived to be a white line. But in any event, in the course of all of these years, from 2018 through to 2023, we are looking at a handful of incidents at most. And in my submission, one does have to put that next to the sheer extent of usage, which, as I say, on a day, albeit slightly further south, is well over 2,000 on a weekday. And this is where Mr. Artist extrapolated in his evidence that, in his view, this cycle track would have been used 1 million times a year. Now, clearly, there are certain inroads that can be made into that. Because
even if it's 500,000, the point is still the same.
It is, my lord, yes.
You say, as against that, there's only a handful of accidents.
Yes. So that's the first point. The second point is the one that I perhaps confused when looking at this, which is the usage of cyclists using this lane going up over time, using this track going up over time, and yet the incidence between other road users staying about the same. There's as I said, there's 8 in the years before the construction, 6 and 5 in the years after the construction. So it's about the same, these reported incidents of cyclists having issues with motorists. But of course, the difference is that the volume of cyclists has significantly increased.
Yes, I suppose. Would also infer that if the layout has been the same for several years, that most, though not all, of the 500,000 journeys a year will be by people who've done it many times before, and so they get used to the surroundings.
Yes, of course.
Yeah.
So we can take those points into account, but I think the submission that I made at trial, and essentially I make again now, was that one has to look at that context. One has to look at the bigger picture here. It's very easy to focus narrowly on these unfortunate accidents that befell the claimants. But what the court doesn't see is all of the users who day in, day out, round the clock, are using this cycle track without any problem, and who it is protecting.
And this feeds into your argument, does it, on this basis, that when you're looking for evidence of the degree of risk that TfL had to manage, either because it was initially quite small or because of the steps they put in place, the degree of risk, you say, on the evidence is very low.
Yes. in my submission, the court has to take into account the low accident rate, has to deal with it, because it goes, as my lord says, to the issue of extent of the risk, which is part of the balancing exercise that the court needs to conduct. That is very clear. The best known speech to that effect from Tomlinson is that of Lord Hobhouse, which I won't take the court to, but for the court's note, it's paragraph 79 and 80 of Lord Hobhouse's speech. That's in Tomlinson, my lord. The need to put the accidents in the context of the fact that 160,000 people a year visited this quarry, and the accident rates were so few, of people having trouble swimming, getting into difficulty swimming. The more helpful example of that principle is the case that I mentioned earlier, Hilliard and Surrey County Council, 2018 EWHC 3156. Again, the notes are, perhaps in the interest of time, I won't take the court to it. It's fairly straightforward. It's a Ride London event where 16,000 cyclists cycle across an area of roadway in Surrey, of which there is a depression, and the claimant comes a cropper, and he's about cyclist number 12,400 of the 16,000 to pass this site.
What year was it?
It's 2018.
No, I didn't do that.
The point being that in that case, the district judge at trial didn't grapple with this issue of number of cyclists using a facility without problem. And had he done, as Mrs. Justice Slade found on appeal, that was overwhelming evidence that there wasn't a significant danger. And it has to be said, of course, that at these margins we're dealing with certainly more than 12,500 cyclists. So fundamentally, in my submission, the learned judge didn't grapple with these points. And in fact, we could just return on this to the judgment at page page 82. The two important paragraphs are 127 and 128. The court will see it's paragraph 127. The learned judge distinguished Tomlinson on its facts without actually dealing with the issue of law that Tomlinson and Lord Hobhouse discussed, which is the need to take into account accident rates when looking at the extent of the risk. And then at paragraph 128, the judge essentially distinguished Hilliard on the basis of Yetkin. Yetkin, as we will see, is a case where Mrs. Yetkin crossed a 6-lane dual carriageway with a central reservation in the middle when there was a red man, and because the central reservation was shrouded by shrubs that had grown so tall that they seriously interfered with the view of pedestrians trying to make the crossing, she didn't see the car that struck her as she crossed on the red man. The point, of course, is that in Yetkin, a number of things have to come together for that accident to have occurred. Mrs. Yetkin needed to cross on a red man. There needed to be a car coming. It wasn't a permanent state of affairs. The danger, such as it was, existed for the period of time that the shrubs had grown so tall that they obscured a view. Hilliard is more helpful because that was a permanent state of affairs in the road for the 12,500 cyclists.
A very odd case. I never heard of it before, but it's not a negligence claim, it's a failure to maintain the highway claim.
It is, my lord, yes, yeah. But essentially, when one is dealing with a Section 41 highways case, the first question is, was there a failure to maintain the highway? Is the highway out of repair? Is there a reasonably foreseeable source of harm? And so it's germane to the same evaluative exercise in my submission. So I say the judge simply failed to deal with those points. The next matter, and I won't spend very long on this, I think I've largely covered it this morning, is that the judge's finding that the defendant needed to have installed these wands as a barrier on top of the curb upstand was novel. It wasn't heralded by any other design standard or common practice. It didn't feature within the defendant's extensive road safety rules. And fundamentally, in my submission, the learned judge failed to take into account these standards, as we've seen this morning. Had he done, and had he properly taken a proper approach to Mr. Coventry's evidence, he would have realised that wands are a method of light segregation that are specifically designed to allow cyclists to go between them. And that's the reference that we saw this morning. The judge failed to take into account that this cycle track complied with the standards, which was another relevant matter for him to consider. We do see in the judgment, while we're here still, that what the learned judge does is move very quickly from finding that there's a foreseeable risk to some cyclists in not essentially identifying the curb. That's, as we saw earlier, at paragraph 135 of the judgment. And then asking himself, what steps should TfL reasonably have taken to remove that risk? What we don't have is any real assessment of the extent of the risk, the extent of the danger. And all of those factors that the court is required to consider when working out, is this a danger that needed to be guarded or warned against? Equally, on the other side of the balance, in my submission, the judge fundamentally failed to tackle the question of whether the measure that he'd identified, namely the barrier of wands, whether that was something that was practicable, whether it was something that was proportionate to the extent of the risk that he should have considered. As we've seen, and in the extracts that I took the court to, the judge's analysis of this is solely in paragraph 147, and suffers from the failures that I've already identified in my submission, that the judge was considering evidence about installing wands instead of a raised curb, not on top of a raised curb. And the judge took the view that there was no good reason why it couldn't have been done. In my submission, that's the wrong way round. The judge fundamentally needed to assess the efficacy, practicability, and proportionateness of the measure that he'd identified. But in my respectful submission, he simply doesn't do that at all. So we do have a fundamental failure here to undertake that Tomlinson analysis. Had the learned judge done so, in my submission, he would have identified that essentially, in this case, the defendant is having to take all the disbenefits of wands on top of all the disbenefits of the step cycle track. So the disbenefits of the step cycle track being the need to install it, for it to be permanent, for there to be excavations, and then the disbenefits of wands, that they need to be installed and then maintained. So it's having the worst of both worlds, essentially, failing to appreciate that distinction, that they are separate alternative methods of segregation. And finally, I do make the submission that the learned judge failed in setting the standard of care that he did. He failed to consider the implications in respect of encouraging defensive practices or deterring the creation of these cycle track facilities, and the trade-off between careful cyclists and negligent cyclists. This is obviously ground that's well covered in Tomlinson. The court needs to look at the end to be achieved and so on, and the utility of the conduct that is subject to the inquiry of breach of duty. That all now has its footing in Section 1 of the Compensation Act, which I dare say the court's very familiar with. But if it would assist to turn it up, I think it's at the very front of the authorities bundle. Page 1 of the authority, so tab 2. Page 4 of the authorities bundle. Which is entitled Deterrent Effect of Potential Liability. A court considering a claim in negligence or breach of statutory duty may, in determining whether the defendant should have taken particular steps to meet a standard of care, whether by taking precautions against a risk or otherwise, have regard to whether a requirement to take those risks might, A, prevent a desirable...
Where are you reading from?
Sorry, my lord, it's page 4, Section 1 of the Compensation Act.
Okay. Thank you.
And Section 1 of the Compensation Act has been accused of being statutory surplusage because essentially it is putting into a statutory form a common law concept that has existed for a very long time. But nonetheless...
Why is it applicable to the present case?
In my submission, my lord, because the step cycle track is... Well, it serves two desirable purposes. One is to encourage people to cycle, and the second is to protect them when they are cycling. And there is a risk, in my respectful submission, that if the private law duty is set too high, in other words, if the judge's finding in this case stands that in order for this to be safe, there needed to be an impassable barrier of ones along this cycle track, then that will necessarily and obviously have implications to whether these step cycle tracks can be created, whether they should be removed, the ones that have been created. That's the trouble with private law setting a standard of care that is too high. So I do make the submission that the Compensation Act is pertinent and relevant. And essentially, the learned judge at trial should have been taking into account the countervailing issues on the balancing exercise. But he didn't. There's nothing in the judgment where he's taking into account those points. So I think with that point being made, that's everything I intended to say on grounds 4 to 6. Essentially, the matters that I say the learned judge didn't take into account but should have done if he was to perform the risk assessment and balance that Tomlinson required him to. Unless I can assist any further, I think that just leaves the Yetkin point.
Oh, yes.
As I say, I will look at Yetkin in some detail. The mischief, if I can put it like that, is this, that Yetkin confirms absolutely that the duty owed for dangers created on the highway is a duty that is owed to both careful and careless road users. And I take absolutely no issue with that. The danger and mischief is that Yetkin can be read, and has been read, in a way that suggests almost that there is an elevated standard of care for negligent cyclists.
You're saying that's what happened in this case, it was read in that way?
Yes, my lady. And I'm only going to take the court to two authorities in my last half an hour. One is Yetkin, and one is a decision of Braithwaite and the London Borough of Lewisham, where a similar issue emerged. That is a decision that occurred after this trial. And indeed, as I understand it, the claimant in Lewisham and Braithwaite sought permission to appeal to this court, and on the basis that it raised similar issues to this case. As I understand it, Lady Justice Andrews declined that permission, the claimant not being able to cite any error of law in Braithwaite. But I will take the court to that case. Those are the two cases I'm going to go to.
Yes.
But yes, in summary, my submission is that the danger of reading Yetkin in that way is that it leads judges to consider that the duty, as soon as there's a foreseeable risk to negligent road users.
Mr. Hedgemans, that's why I was asking whether your argument was that in this case there was an error. I don't think we can talk about judges generally.
Yes, well, I do say that, and my lady will recall, it was this issue that caused the learned judge of his own motion to leapfrog this appeal to the Court of Appeal. Perhaps just to go where I anchor this to in the judgment, it's back to page 82 of the core bundle. The learned judge refers to observations made in Gorringe and other cases that road users are not entitled to suppose that their journeys will be free from hazards or that the need for care will be highlighted so as to protect them from their own negligence. Now, it is inevitably the case that one can foresee that a careless road user will have accidents with pieces of highway infrastructure that are there to be seen. Fundamentally, the learned judge in this case was required to decide that issue. In a sense, it's a part of his assessment of risk. What is the extent of the harm, the danger, such as it was? But the judge directed himself away from considering those points by saying that he also bears in mind Yetkin, that it's reasonably foreseeable that road users will act negligently. And this is, in my submission, the danger that the danger is reading Yetkin in a way that as soon as a reasonably foreseeable risk to negligent road users is identified, that there is then a duty to mitigate that. Or, even as we've seen in other extracts of this judgment, eliminate it. And so essentially, Yetkin can be read in a way that puts the standard of care too high in favour of the negligent road user. So with that being said, it's probably a desirable moment to turn to Yetkin. Yetkin, London Borough of Newham, 2011 QB 827, which is at tab 8. It is perhaps important just to have an understanding of the facts in this case. I summarised them briefly earlier. It's a case in which Mrs. Yetkin was crossing a large road in East London. It was a 6-lane road, 3 lanes in each direction. In the middle of the road was a central reservation that had colloquially been called a sheep pen. I'm sure the court's familiar with it. It's a railed-off island in the middle of the road, in which road users were able to cross the first 3 lanes, enter the harbour of the sheep pen, take a step to the left and then to a right, and then they're at the traffic lights for the following 3 lanes. So it was a piece of highway infrastructure that was designed to take pedestrians safely across the road. What Newham did negligently in this case was they planted shrubs outside the sheep pen that grew so tall that they seriously interfered with the view that pedestrians had of the oncoming traffic, particularly in the fast lane, which is the lane that they were stepping off onto. And indeed, in order to get around that impediment, that obstruction, pedestrians would need to step out, no doubt gingerly, into the carriageway to see if there was something coming. And on this occasion, Mrs. Yetkin reached the central reservation. She didn't wait for the red light. So she didn't wait for the green light. She stepped out on the red light and was struck by Mr. Mahmood's car, who was coming down the fast lane, which was the immediate lane that she needed to cross. Mr. Mahmood was not found negligent at all. The claim against him was dismissed, no doubt, because the Mrs. Yetkin had appeared in front of him and he couldn't see her.
When the lights were green for him and red for her.
Indeed. So Yetkin is a case which doesn't establish any new principles, doesn't take the court, direct the court away from the need to consider that fundamental question of whether there's a real source of danger, and if there is, what is the extent of that danger. All Yetkin does is reaffirm, after an attempt by Newham's counsel to argue otherwise, that the common law is the same test in this area as it is in others. Turning to, just to give the court a feel for what the danger was in Yetkin, at page 126 of the authorities bundle, I'd invite your lordships, your ladyship, just to consider paragraph 3. I won't read it out verbatim. So the court will see there that the Lady Justice Smith is setting out the danger that existed and the interference that these shrubs posed for all pedestrians crossing at this point. Essentially, Newham had designed what had intended to be a safe crossing point and then had blocked up the view that all pedestrians had of the carriageway they were about to cross. So one can see very quickly why Newham was negligent for doing that. Although they planted shrubs, it's essentially the same as had they built a brick wall next to the sheep pen to totally obscure the view that a pedestrian would have in trying to cross the road. But what Newham's counsel attempted to do in Yetkin was to say, well, hang on a moment, there are two special limitations on the duty owed by someone who creates a danger on the highway. And those special limitations precluded Mrs. Yetkin being able to succeed in this case. And those special limitations can be found at paragraph 9. And again, I would just invite my lords, my lady, to consider paragraph 9. So what we can see there is the defendant counsel's contentions about these special limitations that existed on the common law duty in this context. Number one is that the duty only arose if the highway authority created a foreseeable risk of injury to reasonably careful road users. It owed no duty whatsoever to careless or negligent road users. Special limitation 2, the duty was limited to avoid actions which created a trap for the road user so as not to entice them to the danger. pausing for a moment, these submissions are rather remarkable, because if they were right, if, for example, the first one was correct, then one could never have a contributory negligence reduction, because one would, the duty would be owed only to careful road users. The careful road user would either succeed or they wouldn't, and a careless road user is excluded from the duty. So one can see very easily why this made no sense. Surprisingly, the claimant doesn't seem to have argued the peculiarity that that there would be no room for contributory negligence if that limitation were correct, but there we are. The crucial line on this first limitation is that the Highways Authority duty of care arose only if it created a foreseeable risk of injury to the reasonably careful, prudent road user, semicolon. It owed no duty whatsoever to careless or negligent road users. I don't particularly take issue with the first clause up to the semicolon, but the second clause simply doesn't follow from the first. It cannot be said that there can be no duty to a careless road user because the duty only arises if there's a foreseeable risk of injury to reasonably careful, prudent road users, because exactly as I've submitted, if that were right, then when a careless road user is injured by something that interferes or obstructs or is a danger to everyone, that negligent road user would have their claim defeated. So that's the first point. The second is that the duty was limited to the avoidance of actions which created a trap for the road user. Again, I'm not sure trap is really a term of art. I suppose on a spectrum, if one end of the spectrum is things that are blindingly obvious and there to be seen, and the other end of the spectrum is a trap where a road user has been enticed into a danger, then one can see there's a difference in what that means. But clearly it must have been wrong and was found to be wrong for Newman to allege that the duty could only arise in respect of things at the very end of that spectrum for traps and enticements. Fundamentally, what Lady Justice Smith does is go on to say, essentially, those limitations do not exist, and that the Defendant's Counsel in this case had taken the passages in Gorringe out of context.
But this is complete Hornbook law, isn't it? It's as basic as can possibly be.
I
there
agree
are
with
certain circumstances where a different duty can be owed to different people. One example would be trespassers, but that's now governed by the Act. Another would be the duty owed to people taking part in a criminal enterprise.
Yes.
The pillion passenger who's gone out to burgle.
Yes.
But we're not in that territory at all, are we?
No.
Why are we spending time on this?
Well, in my submission, my lord, the mischief that this gives rise to, and I do say that the learned judge fell into this trap, was he essentially departed from the need, as expressed in Gorringe and other cases, for the need to drill down into whether there was a reasonably foreseeable source of harm, and focused solely on the position of the negligent road user. And as you say, we see that in the judgment in the paragraphs that I've taken the court to.
126.
126. But then in terms of where the judge applies, yes, so 126, I say the learned judge directs himself away from the need to really, if I can put it like this, bottom out the question of whether this was a reasonably foreseeable source of harm of the type that a defendant is obliged to protect or guard against, by reference to simply the fact that it's foreseeable that road users will act negligently. Now, the fact that
Sorry, Mr. Edgman, the judge doesn't really say anything wrong about the case of Yetkin. You're just coming back to your submission that on the facts of this case, he didn't conduct the evaluative analysis as he should have done.
Indeed, my lady, but paragraph 126, the point from Gorringe is the point about breach of duty. It's the point about whether it's a type of danger that needs to be guarded against. The point in the final line of paragraph 126 is a point about the existence of the duty of care in the first place. And that's what Yetkin confirms, that careless users are owed a duty.
We've established this morning that a duty of care clearly did exist in this case, and it was all about whether that duty was discharged,
yes,
whether there was a breach. Yes.
But in my submission, in taking into account the statement of the law that that careless road users are owed a duty, as a counter-argument to the Gorringe point, which is, well, what types of dangers need to be protected against or warned of or guarded against, the judge was conflating, in a sense, a duty question with a breach question. That's the trouble. And I do say we see this reflected in the judge's analysis, because, as we've seen, all the learned judge does is find that there's a reasonably foreseeable risk to negligent cyclists. And then the learned judge moves on to identifying 3 methods by which that discrete risk to negligent cyclists could, or in one case should, have been remedied. And that's sort of the focus of the judge's inquiry, is on there's a risk to negligent road users, therefore what reasonable steps should TfL have taken to eliminate that risk. There's no middle point about, well, is this a risk? Even if it is a risk to negligent road users only, is it the type of risk that needs to be guarded against at all? So this is very much from the point of view of the negligent cyclist only, rather than the broader assessment that, in my submission, the learned judge needed to conduct, which is whether this is a risk that required remedy. This is an infrastructure that required...
I'm sorry, I'm being very slow. You accept that there's a duty to all road users?
Yes.
You accept that some road users are negligent and some are not?
Yes.
Doesn't the evaluation by, in your case, TfL, but then by the court, have to be whether the steps that were taken were reasonable, bearing in mind that some cyclists are not negligent and some aren't?
Yes, my lord, it does.
Or is it any more complicated than that?
No, and essentially that's my submission in a nutshell, that the judge didn't bear that in mind. The judge was just bearing in mind the perspective of the negligent cyclist.
There are an awful lot of cases cited to the judge, and usually so for a county court action. Who put all these authorities in? Was it a combination of both sides? Or?
It was. I put in some of them.
Perhaps were rather distracted from the real issues in the case.
That may be. The difficulty is that in a county court action, you could have a judge who's never tried a highways case before. So I do think it's proper to...
They're particularly helped by getting lots of authorities, but there we go.
No, well, that may be so. I suppose all I can say is that council has a duty to ensure that the guidance from these authorities is before the court. I wonder then, I'm not sure we need to consider Yetkin any further in light of that.
Which I'm still of the view that this case is about facts rather than about law. Any further points you would like to make at this stage, Mr. Head?
No more.
Thank you very much. Very grateful to you. Mr. Mooney.
My lords and my lady, I start, if I may, as my learned friend did, with a photograph.
Yes.
He showed you a number of photographs in the bundle showing the scene during daylight. The photograph I'd take you to, if I may, is page 129 of Supplementary Bundle 1. A photograph of the scene at night. As we know, both of these accidents occurred in the hours of darkness. It is also worth remembering that the judge himself had a site visit of the scene in the hours of darkness. So he had, in his own mind, he had seen the site and he had seen what it looked like during the hours of darkness. And I submit that photograph is instructive. I turn now to the general issues in the case, and I submit that there are two issues in this case which complicate and in my submission have confused this appeal. The first is the issue of breach of duty and how, to what extent breach of duty extends to what I'll call the Wands issue. And the second issue is the suggested tension between the Gorringe Authority and the Yetkin Authority, which I suggest doesn't really exist. And on behalf of the respondents in this case, we submit that on a proper analysis of this case, when you strip those two issues away, what is left is an attack on the judge's finding that this SCT in this particular location, at that particular time of day, was dangerous. And that's a factual finding.
What do you mean by dangerous?
Well, in breach of duty, dangerous, in that, as the judge found, that it creates a foreseeable risk of harm.
That's quite a qualification in answer to my question. Because, in fact, what you're saying, when you say dangerous, you're meaning gives rise to a reasonably foreseeable risk of injury in respect of which the TfL had not acted reasonably.
Yes.
I don't think that was necessarily encompassed in your word dangerous.
Well, if I was too broad in my analysis, I apologise. Yes, that's what I submit, and I accept it's as was set out in the case law. It's a fair degree. Why do I say that? And why do I say that when we look at the first issue, the breach of duty issue? Forgive me for going back to basic principles, but if we look at what is the duty that TfL owed to road users in this case, and that's helpfully set out in the Yetkin judgment by Lady Justice Smith at page 130 of the authorities bundle. We can see at page 130, it's paragraph 17, just down from B, in the part that's been marked in red. The common law recognised a duty on any person not to create a hazard on the highway which would affect the safety of road users. So that analyses the duty. The duty is not to create a hazard on the highway which would affect the safety of road users. The extent of the duty would be a matter of fact and degree. Common law has only ever imposed a duty to do what was reasonable or to avoid doing that which was unreasonable in all the circumstances. So we have there set out for us the common law duty of care owed by TfL to these claimants. What then did the claimants allege, say the respondents allege in their particulars of claim, that the TfL had done wrong? And we can look at that, please, at divider, start at the back, divider 13, which is the Upitis particulars of claim, page 145, the particulars of negligence. In that, counsel for Mr. Upitis pleaded as follows: defendants, employees or agents constructed a cycle track using a curb upstand with vertical sides and the same presented a foreseeable risk of injury to cyclists. So he is specifically pleading that duty of care which we've just looked at in Yetkin. I turn now back in the bundle, please, to divider 10, page 112. These are Mr. Young's particulars of claim.
Sorry, which page?
112. Now, without wishing to embarrass my learned junior, these are not quite as clear. But if we turn to page 112, subparagraph 8, causing and or permitting and or leaving a curb upstand to be or remain on the road and to remain a danger and or to trap persons lawfully using the road. So again, it is pleading specifically that duty that we saw set out in Yetkin, common law duty not to create danger on the roads.
It's pleading breach, just to be a bit pedantic,
Yeah,
rather than pleading the duty.
yeah, I'm grateful. Having looked at what was pleaded then, we come to what did the judge do in relation to those pleadings? What did the judge recognise as his duty when deciding what the duty of care was and whether there had been breaches? We start, if I may, at page 82 in paragraph 124. Actually, do you mind if I go back to page 64 and start at paragraph 13? Forgive me. Paragraph 13 of the judgment, the learned judge says this, just over halfway down that paragraph. Mr. Young and Mr. Upitis both claim that their injuries were caused by TfL negligently creating a hazard on the carriageway by installing a curb with an upstand, of which there was no adequate warning. So he's clear that what he is being asked to look at is, or what he's being asked to decide is, did TfL breach their duty by putting in place a curb with an upstand of which there was no adequate warning? He goes on, at page 78, paragraph 103. to say the law, the claimants rely on breach of common law duty of care owed to them by TfL. And we've already looked at what that common law duty is. And then I turn to where I initially started, page 82, paragraph 124. And this, I submit, is the crux of what the learned judge understood he was deciding. I agree with the claimants that the construction of the SCT was a positive act by TfL. TfL was therefore under a common law duty to road users.
Sorry, I haven't got the right paragraph.
I do have it, 124.
Thank you.
Try my lady. Second one down on page 82.
Thank you. Yeah.
I agree with the claimants that the construction of the SCT was a positive act by TfL. TfL was therefore under common law duty to road users, including cyclists, to construct it in such a way that it gave rise to reasonably foreseeable risk of harm to them. Not to construct in such a way that it gave rise to a reasonably foreseeable risk of harm to them. However, TfL was required to do no more than was reasonable to avoid such a risk. So when he poses that question, when he looks at that, when he says that in his judgment, he's effectively setting out exactly that test we looked at Yetkin, where the duty is set out in Yetkin. And then my learned friend has discussed at length the findings of his breach of duty, and it is interesting, I have to concede, that nowhere in this judgment does he actually say, I therefore find breach of duty for the following reasons. But I submit that the crucial passage, having gone through what we've just gone through to look at what he was considering and the issues that he had in mind when he came to his judgment, is the top of paragraph 148 on page 86. And there he says this: in summary, I am satisfied that by installing a curb with a vertical upstand on the stretch of the SCT on Farringdon Road between the junction of Ray Street Bridge and the junction of Clerkenwell Road, TfL created a hazard on the highway which posed a reasonably foreseeable risk of injury to cyclists. And I submit that is his crucial finding.
But that's not enough to get you home, because you have to go on to show that he found and was entitled to find that there were steps which TfL reasonably should have taken but failed to take.
Well, I submit the duty is not to create a danger or a hazard on a highway. I submit that by finding that this stretch of road creates a hazard on the highway which posed a foreseeable risk of injury to cyclists, he has found breach of that duty.
With greatest respect, that is directly contrary to the paragraph which you were pressing on us a minute ago, paragraph 24, which has as an integral part of the test that you're relying on, TfL was required to do no more than was reasonable to avoid the risk. And what I think my Lord is picking up with you is that a mere statement that there's a danger doesn't address that problem of what is reasonable for them to do at all.
Well, when he assesses what amounts to a danger, he will have assessed, he's effectively making an assessment of what TfL have done. And he does that in this judgment.
Where?
Well, what he does when he goes through TfL's actions, I think it's paragraphs 125 to 135, is he sets out the history of this, and he sets out what TfL, in fact, a bit further, sorry, forgive me, it's not those paragraphs, it's paragraph subsequent to that. He sets out in the judgment how TfL, at the first stage, identified a risk to cyclists, exactly the risk that eventuated, the risk of a cyclist mistaking the upstand for a white line and trying to cross it. They identify that. They then put in place measures at stage 2 which they decide are sufficient. And then he goes through the history of the accident, Mr. Hoptoff, and the history of slightly widening the white line to mitigate that. And effectively, he has found, at paragraph 148, that they were insufficient measures because he's found it remains dangerous.
No, if you go through, forgive me, if you go through the passage that you've just flown over at high speed and high rate, you could support what the judge says up to 135, where the question of the court is whether in light of widened curve, painted double and lines, so on and so forth, whether there were any other further steps that they should reasonably have taken to reduce the risk so that it was no longer reasonably foreseeable. But leave on one side whether that's an accurate, the last two words are accurate. He then comes up with three possibilities, of which he rejects the first two and says the third is wants. And then you have to face the attack on that from Mr. Hedgeman. But there's no, those are the only things that he is putting into the possible mix.
Yes, but I submit that he finds that the duty of care is not to create a hazard on the highway, not to create a foreseeable risk of harm to road users.
No, I don't agree. With the greatest respect, I don't agree. It's why I picked you up when you first said it. The duty of care it's a duty of care, which means a duty to take reasonable steps to prevent or in the face of a foreseeable risk of danger. And you, every time you come back to this, you're leaving out the reasonable steps or the nature of negligence, which involves doing no more than is reasonable.
I thought if you look at paragraph 124, Mr. Hedgeman agreed that 124 is an accurate statement of the law.
Yes, he does. Well, he did in oral submissions.
Do you?
Yes, I do.
Well, but you seem to be leaving out the last sentence.
No, because when they are, what we are saying is that their design of this this upstand and this cycle lane is negligent because it gives rise to a reasonable foreseeable risk of harm. Therefore, they have not done all that is reasonable because they've ended up with a dangerous design.
That's completely circular.
Just have a look at paragraph 130. Because the judge finds there that TfL considered the potential hazard posed by the curb and took steps to address the potential hazard. And they are the road markings, the
red lines, the triangle.
It also is the wand actually, but he goes on to deal with the wand stroke bollard later. And he says there, in my judgment, that was a reasonable approach for TfL to take at stage 2. So that's a clear finding by the judge that in relation to the inherent danger of leaving a step, those measures were reasonable.
So my lady's approach is that he has found effectively at that stage they have acted reasonably, and it's then thereafter when they get the further accident, Mr. Hotpoff, that is when they need to act again. And he finds in relation to that they have widened the road, and then he says later on in the judgment.
When did Mr. Hotpoff's accident happen in relation to the claimant's accident?
2018.
Yes.
Before
4th of June 2018.
So
Yeah.
before both
Yes.
these accidents. So it's not a further accident, it's when they've had a report of
After having
an injury.
After having had a report of an accident injury, they go back, and the judge finds that they have identified, and this isn't challenged, he finds the judge that they have decided that they have created something with a foreseeable risk. He says that, and that's why they change it. That's why they widen the line, widen the curve.
Yeah.
Now, so if I'm wrong on my submission that the mere creation of a dangerous, of a foreseeable risk of harm to cyclists is negligent, if I'm wrong about that, then we move on to the next stage. Well, the judge having decided at paragraph 130 their actions have been reasonable to date, he then says, okay, we've had the hot hops. We've had Mr. H's accident, and he finds that TfL now believe that there's a reasonably foreseeable risk of serious injury because of and so they choose to take further steps. And in effect, what he then finds is those steps are not sufficient.
But he finds that paragraph 135. He says, I'm satisfied that even without widening the curb was widened, painted double red lines and a painted white triangle would have been sufficient to warn a reasonably careful cyclist not to attempt to cross.
Well, and that's where we get into the Yetkin argument. And that's right, he has found that what TfL have done is sufficient to protect reasonably careful cyclists. What he finds is what they have done is not sufficient to protect non-careful or negligent cyclists.
Your case was that it was inadequate because it failed to provide a warning, which should have been provided by bollards, and you lost on that.
That was the case that was pushed in the court below, in the county court. And they did lose on that.
Which he described as a red herring. So where's his finding that it wasn't sufficient?
What he says, and I'll just find the passage, is the decision to widen the curb was he describes it as a minor, I'll find the exact wording, but he describes a minor tweak effectively. And I submit there he's saying it wasn't enough.
Yes, so he finds, at 130 he finds reasonable at the design stage. At 135 he finds that the measures there excluding the bollard, were sufficient to warn reasonably careful cyclists. And then he makes his findings about the bollard not being causative. And then 143, he says, returning to whether the curb posed a reasonably foreseeable risk of injury.
Yes, and that's the crucial passage there. Returning to whether the curb posed a reasonable foreseeable risk of injury. The widening of the curb is quite a subtle measure.
It'd be easy to mistake it for a continuous white line. He makes that observation having seen the photographs, but also his site visit.
Indeed. And so what I submit is, if I'm wrong about my position that the mere dangerousness renders the TfL negligent because of paragraph 130, we then move on to what did they do when they realised they had created a danger. What they did was widen the white line, and what he says about that is it was a subtle measure, and it plainly didn't work. And I submit that is...
I mean, you accept in your skeleton argument that the judgment might have been clearer in part.
Oh, absolutely.
But you place quite heavy reliance then on paragraph 143.
Yes.
And from there, they should have done.
Indeed.
more.
So at that point, we've reached a stage where they have identified that they've created a foreseeable risk of injury. They need to think about what they do about that. And their attempts at resolving the issue, so the stage further that your lordships have taken me to and suggest that I need to get over, is, well, what do you do? Well, they widen it. He says that effectively that's not enough. Now, it's right to say he goes on to think about these three further measures, and he alights on the wands measure as the panacea for mending difficult raised cycle tracks. But I submit he didn't need to do that. He's done enough by effectively saying there came a point after Mr. H's accident where you had to decide what to do. You made a call and it wasn't good enough because there further accidents occurred, and therefore you haven't done enough to turn what you accept is dangerous into a safe cycle path.
What are the implications of this judgment? If it stands that, well, if let's deal with it first on the basis that Mr. Hedgeman's right and the WAND's solution is not open. Just humour me for a moment. The judge has identified three potential, and now let us assume he's rejected all three. There's a foreseeable risk of injury. What do you say TfL are meant to do then? Tear the whole thing up?
The judge also says there may be other things I haven't thought about.
I'm asking you to think about them.
Well, I'm thinking, we looked earlier at the guidance, and it was interesting to note that the cycle path was coloured blue. It was a totally different colour to the road. That's something that wasn't canvassed. But
There was something in the evidence, actually. It was canvassed in the evidence, and the blue became slippery, which is why it was rejected. But you could colour it differently. And the point here is that the dangers created, we go back to that photograph at 129.
Blue wouldn't demonstrate that you've got an upstand.
Well, it would demonstrate, well, it depends on whether if you made all upstand cycle paths a different colour, then anybody using a cycle will understand and they saw a different colour, they were a different upstand. But I accept I'm now speculating on a whole area of cycle path construction. I'm not sure what to do.
So don't be too embarrassed about it.
Can I go back to my photograph on page 129? The danger that the judge identified and that TfL identified is that there is a continuation, effectively, to the naked eye and to, admittedly, a careless cyclist who doesn't particularly pay attention to the red lines, that they think it's simply a white line. Well, that's a difficulty with using that colour of curbing. You could use a different colour curbing. My learned junior hands me a note saying warning signs, upside curve, but I'm not going to go there. further route. But it seems to be that the particular mischief which caused this accident, and these accidents, and it's not disputed, it's been accepted in evidence by my learned friend that the two cyclists simply believed that they were crossing a white line, not a curb, is dealt with by changing the colour of the curb.
Where is consideration in this judgment of the severity of the risk? We've got two negligent cyclists, both of whom say they were very experienced cyclists and certainly should have known better. Where is consideration of the extent of the risk?
Well, I accept that, save for the paragraph, I think it's 121, where he looks at the Hilliard judgment and talks about that. No, it's 128. There is limited, I use the word advising limited, discussion about the number of cyclists and where that takes us. But, of course, the judge has two things to consider when he's thinking about risk, and I accept it's not set out in his judgment. But the first thing is there's the incidence of accidents is one issue, but the nature of potential accidents is another, and the potential harm. Now, whilst he doesn't deal with that at length, I submit that the vulnerability of cyclists, as recognised in numerous cases and in the Highway Code, is so obvious. He doesn't need to say if a cyclist falls off on a main artery in London, he might get run over by a bus. And that's a very significant harm. So that is one element he has to balance, that there is a real risk of harm to cyclists. It's not that they might just fall off and hurt their knees or break a bone. It's that if they fall into the road, they're in real difficulties potentially. And that, I submit, is something that is so obvious, it doesn't need him to set out, and I bear this in mind. It's recognised in the Highway Code, it's recognised generally. He does deal with the incidents to an extent when dealing with the Hilliard judgment in 128. But of course, we've already looked at the study that was done, dealt with a different section of the road, and not this particular SCT, and therefore this caution must be applied. And also, we've got to remember that there are...
Doesn't really make much difference, though, does it? There were lots of cyclists going down this route.
Yes, but some will be coming down the route that these two claimants were coming down.
Yeah.
And some will be turning from the left, they'll be coming onto the road.
Turning off Clerkenwell Road onto...
And they will be following the raised cycle paths. So they'll be, for them, it's just more of the same. It's those coming down Farringdon Road who have had to deal with the different
I'm not sure it is more of the same. I don't think on Clerkenwell Road they're on-stepped, would have been on-stepped.
Well, it's all part of the same cycle track. So I thought it was.
Well, anyway, more to the point, whether Clerkenwell Road would have represented a change going into Farringdon Road, we need not consider. But the point is here, going straight due south down Farringdon Road, there is a change.
There is a change.
As we saw this morning, this is mentioned in Mr. Young's particulars of negligence, paragraph A, but it doesn't seem to have surfaced after that, whether it was even argued at the trial.
Not being there, I can absolve myself from the...
Yeah.
But no, as I conceded in my skeleton, the judgment is not entirely clear at certain points. But I submit that when you stand back and take a holistic view of this judgment, what this judge has found is they created a danger. They knew they created a danger. They had to sort it out, and the steps they put in place to sort it out were insufficient. Now, the question is, do we need to go on and answer the question, well, what should they have done? And I submit we don't. But if you say he did need to go on and do...
That's because you say the defendants then bore an evidential burden.
Yes. And then we come on to this whole point of the Coventry and the other witnesses' evidence. Artist, I'm grateful. Because what is said about that is, well, they cross-examined Mr. Coventry about the design. He wasn't the designer. Well, neither is Mr. Artist. If we look at the cross-examination of Mr. Artist, one of the first questions that was asked of him was, what did you do? He said, no part in the design. So the witnesses that were sent to court by TfL did not assist anybody in why this was designed in the way it was. And for Mr. Hedgeman to criticise the way the cross-examination was put to Coventry, that's because he was the first witness in the witness box. And then when they asked Mr. Wright, he said, no, I didn't design it. And I come back to the point that when we're looking then at the evidential burden your Lordship raised this morning, we're in a situation where the respondents were told, or certainly one respondent was told at CMC, you can't have an expert because you don't need one, because our design team will be telling you what happened in this case. They then tender Coventry and Artis to give evidence, and neither of them are part of the design team. So it's very difficult to then criticise a county court judge when he's asked now, in the cold light of the Court of Appeal, well, his evaluative judgment wasn't very impressive. He didn't have very much evidence to go on. He's stuck with what he's got and what is presented to him by the parties. And I remind the court, this was a county court case dealing with fairly modest judgment, fairly modest values. That would have been budgeted. There are finite resources that either the court or the parties should apply to these kind of cases. And I submit that actually this judgment, for all the vagaries it may have, does not do anything. It deals with what was in front of this judge. And on the basic issues of what have they breached their duty, he found they had. And then he got sidetracked to an extent in trying to suggest what they should or shouldn't do. And that was an exercise he didn't need to contemplate, really. And we can see from the supplementary judgment that he's got very aerated by the wands. But the reality is, if he has found as a fact that what they had done to date wasn't sufficient, he could have stopped there. And if the defendants aren't going to say, well, actually, there was nothing else we could conceivably have done to make this better, that's as good as it gets, that was for them to put forward, and they didn't.
They could have stopped at 143 effectively.
Yeah. And Mr. Hedgeman could have re-examined any of those witnesses, but he chose not to.
You'd still expect and need some level of evaluation about the extent of the risk before you said, effectively, you've got to tear this up.
Well, he evaluates the risk by looking at what TfL have done and that they have identified a risk. So he says he finds that TfL have agreed that this is a foreseeable risk of harm.
Yes, and last time you approached this formulation, you ended your sentence with the word insufficient. But that doesn't really help, because it's insufficient in one sense, in that both your clients were injured. So in one sense, it's clearly insufficient in that it doesn't provide a guarantee of safety. That's not the question. The question that the court has to determine is whether they're legally insufficient, not reasonable. That's what worries me. I may be alone in my worry, but I have to tell you that's what worries me.
And so the criticism is that this judgment contains no evaluative process at all.
None at all.
Well, what he does look at, and I hesitate and fear to tread onto the issue of wands, but what he does do is look at what Mr. Coventry says about the costs. So he is thinking in his mind, well, I've got a risk to negligent cyclists who are going to come down this road and potentially think they're crossing a white line rather than a raised curb. I can see that TfL recognise that risk as well. I agree with them, it was a foreseeable risk of harm. Then he looks at, well, okay, well, how difficult is it to do something about it? And he finds not very, because these wands are not particularly expensive and quite easy to install, based on what Mr. Coventry has to say. Now, so he was thinking about the other side of the equation. He wasn't just thinking, okay, well, someone's been injured, it must be a foreseeable risk of harm. He was also thinking, well, okay, I build into the matter, we have a foreseeable risk of harm here, there's a risk to cyclists. Is it going to be that difficult for the local authorities, for TfL, to do anything about it? And he finds no. So there is an evaluative process going on in his mind. And what I submit is if you deal in what is a county court hearing in a relatively modest value case. That evaluative process in the scheme of the resources needed to deal with this case is sufficient.
Not insufficient.
It is sufficient. There was certainly no win in front of mine. And I again say that in looking, when looking at the evaluative exercise, he did have limited information because there was no expert evidence, because the defendants put in play, called witnesses who were not part of the design team, and because the only evidence he really had about the other side of the equation was that cross-examination of Mr. Coventry dealing with the cost of the wands. Now, if the defendants had wanted to say, we widened the curbing to make it safe, and quite frankly, that is as far as anybody can take it. It was up to them to call that evidence, and they didn't. And what the judge did do was make a number of findings of fact, which I set out in my skeleton argument, where he goes through exactly why he is concerned about this layout and why he thinks it might be dangerous to people that aren't paying full attention. I had anticipated at the outset of today that I'd be spending a long time explaining why Yetkin and Gorringe have no tension at all. But I'm not sure I need to do that. I can if you want. Yeah. And why the Yetkin judgment says what it says about negligence and contributory negligence. The submission of the learned friend seems to be developing his skeleton argument that it has to be a negligent, only if a non-negligent claimant, only if it would be dangerous to a non-negligent claimant, can you then engage whether it's dangerous to a negligent claimant. I submit doesn't take him any further at all. It's a rehash of Yetkin. It doesn't actually add to this case at all.
I suppose the only thing that one might note in passing is that the thing that in Yetkin gave rise to the danger, namely the overgrown planting, served no safety purpose whatsoever. Whereas here, it's a point of distinction between this case and the other. This case is more complicated than Yetkin in that there are implications for the safety from cars if you don't have the upstand and so on and so forth, all the stuff which has been...
Yes, I accept that point. But I also...
Otherwise, Yetkin doesn't really take matters any further.
I suspect that it would be argued in Yetkin, applying one of the learned friends' points on the Compensation Act, that having attractive flowers on islands is to the greater good. But,
not if it creates a danger of something like what happened to Mrs. Yetkin.
No, but the Yetkin point is that effectively the highway authority in that case have created a hazard, and that is the duty of care. The hazard was created by them allowing the flowers or the plants, the bushes to grow too high. The analysis and the comparison I draw is in this case, they have created a hazard by creating an upstand that is not easy to see against the surrounding and against the pre-existing white lines. So while I entirely accept your Lordship's point about the benefits that these cycle paths may have in other ways, the comparison is, well, they are both creations on the highway by a local authority or by a highway authority, which create problems for potential road users and for road users that may not be paying full attention. Unless you need me to deal with any other of the points my learned friend raises, it seems to me that this case probably comes down to his ground 5, the failure to do a full evaluative analysis in this case. And what I finish with on that point is that this was as is set out in the duty set out by Justice-Smith in Yetkin, it's a matter of fact and degree. And this was a decision by a county court judge who had seen the site, visited it in the hours of darkness, who carefully analysed why it might be dangerous, who carefully analysed what TfL had thought about that, and made findings of fact that it was in fact dangerous. He then found, I submit, that what they did was insufficient to make it reasonably safe. Those are all findings which I say fall within the generous discretion of a county court judge doing his best in the constrained circumstances. Whilst I concede the evaluative exercise, particularly paying attention to the points that is making about the number of potential cyclists on, is not as full as it might be. What I submit is that is, I'm afraid, the outcome of a knockabout county court case. What I also submit is that the Hilliard case and the number and the volume of users is only superficial, is only useful to a limit. And I say that for this reason. The Hilliard case, of course, the cycling case, the cycle race case, is a Section 41 case. So it's dealing with, is this a danger? And of course it's relevant that if in the space of one day 12,000 people have already gone over a particular bump without falling off their bicycles to decide whether or not that's a matter of disrepair. This is a different matter. This is a upstand, which is plainly dangerous if you hit it on your thin-wheeled racing bicycle going down Farringham. That is not an issue, whether or not you're going to be in difficulties. If you don't know it's there and you effectively go sideways onto it, it's plainly going to cause difficulties to you. The fact that not many people have done that does not render it safe. It just means that, for whatever reason, there have not been that many reported cases. So it's a different case to those ones where you're saying, well, we can apply the numbers to say it can't be dangerous. I submit that's not right, because it needs the combination of factors of A, being a cyclist that's coming down Farringdon Road and confuses it for a white line. It may well need the element of darkness, which is why I refer to page 129 in the photograph, and the judge looking at it at that time. And therefore it does restrict the numbers of those that are going to have encountered it in that way. And we do know that it's more than one. It is a number of people who have reported problems and fallen for the same misfortune of mistaking what is an upstand for a white line. And that, as the judge found, is not unsurprising given the layout.
You really say paragraph 124 states the test correctly. Paragraph 143 makes the remaining finding of fact that you rely on, and that's it.
Yes, 124 sets out exactly what the test is. 143 takes us through what he's found and why he gets to where he gets to, and that is the point at which, and in light of your lordship's concerns about my first submission, that is where we must get to, which is okay. Well, when you've identified that you've got a problem, what do you do to solve it? And what they do to solve is not sufficient.
You referred to the judge's discretion. I'm conscious I'm being a little bit pedantic this afternoon, but he didn't have a discretion here. He had to reach a judgment.
Yes, I put it another way.
If the finding opens him is what you're saying.
There are a wide range of potential outcomes. There's a range of potential outcomes in this case. And had the learned judge found that this was not dangerous, and that actually that all reasonable steps had been taken, that too would have been a reasonable judgment, just as I submit finding that it was dangerous and not all reasonable steps had been taken was a reasonable judgment. They're both reasonable outcomes that shouldn't be interfered with, I submit. I'm very aware that there are a number of grounds of appeal which I haven't really dealt with, but it seems the way the court was going this morning and the early part this afternoon that really we are dealing with this, the judge's decision as to whether or not this was dangerous and whether or not all reasonable steps were taken and whether or not he applied the appropriate evaluation.
You don't give in lately.
Yeah.
She doesn't sound passive aggressive.
No, she doesn't.
Both parties ready.
That's what commentary said.
Court rise able.
Do sit down, everyone. Except Mr. Mooney. Mr. Mooney, we haven't decided what we're going to do in this case yet, but we would like to ask you this. Suppose we concluded that any or all of Mr. Hedgeman's many criticisms of the trial judge were correct, and that the judgment shouldn't stand, what would the consequences be?
Well, it would depend on the particular criticisms you were finding attractive.
Yes.
Because if it's a simple failure to make an evaluative, to perform evaluative exercise, it's whether or not you feel able to perform that exercise on the evidence you have in front of you, or whether it's remitted back to the county court.
Yes.
If it was on, well, it seems if it was on one of the matters of law that were raised earlier, that's a different matter altogether.
Yes. Yes. Right.
But does he want to ask anything else?
Sorry.
Does he want to say anything?
There are two small points I've been reminded of.
Of course, yes.
I'm grateful.
There was the
One
cryptic message.
with your lordship's, I've deciphered the note.
Yes.
Your lordship's position in relation to the potential impact of a finding that there was negligence in this case, and how that might impact on the wider network. It was made clear by the judge in this case that he was dealing only with this particular stretch of cycle path, and clear that this has its own unique features given the rundown to Farringdon that we've looked at and your ladyship looked at this morning. So I submit that it doesn't necessarily have wider consequences at all. It deals with this particular area alone. Finally, and it's a very minor point given my views on the relevance of the wand issues, it's been said and submitted by Mr. Hedgeman that use of wands on top of a raised cycle path, the LSCT, is unprecedented. Well, you may have seen that it is clear from the witness evidence of Mr. Young, the first claimant in this case, that he sets out at paragraph 15, page 122 of the supplementary bundle, a cycle path.
Sorry, just give reference again.
It's page 122, it's a very small
Thank
point,
you.
page 122 of the supplementary bundle,
Thank you.
paragraph 15, and he exhibits to that document photographs of a cycle path near him in Stockwell where there are wands on a raised cycle path, albeit 3 of them in a row at the beginning of the cycle path. So I simply say there was evidence in front of this judge that he wasn't simply plucking an idea out of thin air. There was some evidence for it. But you know my submissions on the relevance of the ones in any event.
Indeed, sir. Can I ask one question, and it may be Mr. Hedgeman's better placed than you to answer it, but the judge went to have a view. Presumably he told the parties or asked the parties whether he should.
You went with him, didn't you?
Yes, we all went.
Oh, right. Yes, good. Well,
So I can say this. It wasn't clear whether we were going to have a view. The judge decided halfway through the trial that he should have a view.
yes, well, you didn't submit that he shouldn't. I mean, we were all brought up on the view, on the rule that judges should not go and inspect a locus without telling the parties that that's what they're going to do. And if you all go together, then no complaint could possibly be made. Good.
I'm confident if he'd got that wrong, it would have found its way to Mr. Hedgeman's closing argument.
Right.
I don't know if it's a helpful question or not. It may not be. But essentially, you're saying paragraph 124 sets out the test
Yes.
clearly. Paragraph 143 answers the test.
Yes.
And really, we can take that as the judge applying the law correctly
Yes.
and answering it within the limits of a county court.
Indeed, and the crucial point is he analyses, I submit, what they have done to put right what they accept is a risk, and they don't do enough.
The problem with that is he doesn't just stop at 143, and he analyses various other aspects of the evidence, and the point about the bollard.
That's why, my lady, I say you have to step back and take a holistic view of this judgment, because there are all sorts of avenues that have gone down, and the supplemental reasoning is perhaps not helpful at all to anybody. It doesn't add, I say, anything to the original judgment. I think Ms. Hedgeman agrees with me, but for different reasons. Yeah. But when you analyse the segments of the relevant parts of the judgment, it is clear that there was sufficient in his judgment to deal with the breach of duty, to deal with what has gone wrong, and to say that's where it was. Now, you're right that he then goes on and does other things. I submit he didn't have to.
And that doesn't...
And that doesn't impinge on what the bits he got right.
Thank you.
Right. Thank you very much. Mr. Hedgeman.
My lord, I don't have any further submissions. There's nothing I think I need to come back on unless there is anything that I can assist further with.
Yes. Can I put to you the same question I put to Mooney? Suppose that any or all of your points are right, what would the consequences be?
But it is, I agree with my learned friend Mr. Mooney, it's ultimately a matter for this court. I suppose what I say is this, that we're not dealing here with issues of primary fact, or certainly issues of credibility. We are dealing with an evaluative function on those facts, and this court has before it all of the material that the learned judge did. I would invite this court to consider essentially performing that evaluative function that I've submitted was lacking below. This court can stay faithful to the learned judge's findings that the danger such as it was reasonably foreseeable only to careless cyclists, and can consider those factors in the breach of duty analysis that I have raised in my skeleton.
Thank you both very much. I'm very grateful to you. glad that it was possible to resolve the matters in a day. We will reserve judgment. We will let you have the judgment as soon as we can, but it may not be, almost certainly will not be this week. After that, we'll have to see. Could you please, if you haven't already, notify the court office or my clerk of points of contact during the holiday season in case we send out the draft judgment in August or September, that there is somebody who can look at it. It doesn't necessarily have to be you two personally, but somebody in your backup teams, such as they are. We, as you know, we send out the judgment in draft. Draft doesn't mean that we want the case re-argued. We don't, but just for correction of obvious factual errors, dates and so forth. And it will then be formally handed down by being published on the National Archive website. Any consequential matters such as costs should be dealt with by submissions in writing. There will almost never be a further oral hearing to consider the form of the order, and the contents of the draft judgment are confidential to the parties and their legal advisors until formal hand down. That's all, I think. Thank you again very much for your assistance.
Court is able.